Okay, so the recording has started. Hello, everyone, and welcome to another session by Tathya Walk the Law. Tathya is an organization which aims to bridge the gap between legal knowledge and the practical world. Today we have a very special guest speaker with us, Mr. Solomon Okedara. I hope I pronounced your name right. Uh, we are we are very happy to have you on board, sir. And to give a brief introduction about Sir, he's an experienced legal practitioner and researcher over 14 years and has an interest in human rights with a special bias towards freedom of expression and digital rights, along with privacy, data protection, artificial intelligence, e-commerce, corporate transaction, employment law, and it's just an array of subjects he's interested and very enthusiastic about. Sir, our viewers would be very curious to know about your journey, about how you actually became interested in these fields of law and what made you research or even practice in this field.
Thank you so much. It's my pleasure to be here today. And let me first of all say, of course, for since the commencement of my practice as a legal practitioner, I have actually been allowed to the twin of what is it called? Litigation and research. For me, and of course, I've always loved to strike a balance between the two. So, and of course, foraging into digital rights, especially, was actually when I underwent a particular research fellowship with an organization called ICNL, International Center for Not-for-Profit Law, Washington, D.C., United States. So when I underwent the particular research fellowship program, I actually focused on how social media leverages human rights, particularly freedom of expression. So I looked at this freedom of expression, assembly, and association. Now, up to that moment, many of us had actually known freedom of expression, assembly, and association to only be exercisable offline. But today, social media has enabled us to be able to express those lines online. And that was actually the focus of my paper, and that actually launched me into the deep of what is known as digital rights.
Okay, sir. Shwas, if you
Yeah.
could carry forward.
So, yeah, yes, yes. Sir, you mentioned in your introduction that you're a digital rights lawyer. I'm sure that has made our viewers curious what you do exactly as a digital rights lawyer. Can you please elaborate on that, sir?
Okay, thank you so much. As a digital lawyers, as digital lawyers, every day you are actually involved with working around on concept of digital rights, including data protection and privacy, digital identity, and of course, online expressions. Now, of course, there are some other areas of digital rights which also include right to online content and right to own digital access. In fact, so it also includes right to digital access. Digital access this time around is talking about right to internet. So, and of course, the other side is the right to own digital assets when we're talking about cryptocurrencies. So, but for me, I have special bias for the free of the data protection and privacy, online expressions, and digital identity. Now, so I work on this subject both within the courtroom and outside the courtroom. Within the courtroom as a litigator, outside of the courtroom as either advisor and researcher. And these are realities that we live with every day of our life today. I can tell you clearly that today, there's no offline life again. Every single thing we do is done online now. Now we can get education online, we can worship online, we can do transaction online. We do almost everything online today.
Yes, sir. While I was reading about what you do as a legal practice researcher at Columbia University, as well as a litigator in Nigeria on freedom of expression, digital rights, defamation, etc., there must be some inspiration behind this hustle on these particular subjects. Would you like to tell our viewers about it?
Thank you so much. Now, I must say it clearly that the good thing is that the realities and the dynamics of digital right live with us every day. Let me start with social media. Now, almost everyone all over the world, I mean, when you gather 10 persons around the world, you will see at least about 5 of them only one social media account or the other. Maybe Facebook, Twitter, LinkedIn, Instagram, and some other ones. Now, these social media accounts have been able to give people a cheap and easy access to express themselves, to give expression to their right to online expression. Now, with this reality, now there comes the rise of issues like defamation. Let me give you an example. If you go on your Twitter page and you tweet, "Hey is a thief," now, and I retweet your post. Now, the realities of defamation today is that if your tweet is found to be false and defamatory, I am as liable as you are. Now, when you look at it, that is actually some top-notch higher than defamation offline. When defamation offline is made, now, most of the time, the primary maker of that defamatory statement is solely liable. But today, hundreds of other persons online can be as liable, or as made to be liable as the primary maker of that statement. Now, so the concept of digital right, as much as it comes with its advantages, it comes with many other challenges. So then that actually gave me so much reason to consider the need to work more as a digital right legal researcher and litigator. And I tell you that the two of them are quite complementary.
Okay, thank you, sir. Sir, being a litigator and a researcher at the same time and working extensively in both the fields, how do you manage to keep up in both the professions simultaneously?
Okay, so the truth is that, as I can tell you, that the two of them are quite challenging. They are challenging because as a litigator, you need to sit down in the office, prepare your brief. Now look at authorities around the world. Now, most of the time, your case you're actually working on, the court in your country have not made a decision on it. Maybe it's India, you can find a decision. Maybe it's Kenya, perhaps it's Australia. So while you are doing that, then that actually still takes you to legal research, because actually legal research is the bedrock of a successful litigation practice. Because when you do not know what is the principle, what are the judicial authorities, now in what nation has their court decided on this that can support my case? So for me, it's quite challenging because I can tell you quite frankly, as much as I'm actually juggling between one courtroom in Lagos, another in Abuja, I still have my cases, for Colombia to work on, to analyze. And I tell you, for example, in Colombia, now the Colombia project covers over 100 countries. I mean, judgment in over 100 countries around the world. So sometimes there's so much to live up to. But I can tell you, when you find it so interesting, no matter how challenging it is, it comes, naturally to you as something as endearing as eating chocolate. And that's for me how I'll be able to strike a balance between the two worlds that are quite challenging.
Yes, sir. So you previously mentioned that being a researcher and a litigator, both are these two professions are complementary. So did working as a litigator first have an effect on your decision to be a researcher? And could you please elaborate in to what extent are these two professions complementary?
Thank you so much. For me, I think I actually started first as a litigator. Then, of course, when with time, because I realized that the bedrock, the success of every litigator lies in very sound habit of research. Now, in those days when we're in the university, we're taught that, the school teaches you how to think, but you teach yourself the law by research. Now, so what the school does to you is that it constrains your mind to think to solve a legal problem. But you now have to teach yourself by finding out, the solution, to that legal problem. So the point is, for me, I started first as a litigator, but as time went by, I saw a need to deepen my research skills. And that took me into digital rights. And of course, being complementary is because while I was, for example, when I did my first paper on digital rights, now it was then I realized that what was the legal problem, that the paper was to solve was actually resolved by the Supreme Court of India in 2015. While I was getting excited, I realized that close to me in Kenya, a high court also resolved the same problem. Now look at it. If I wasn't a researcher, now I would just be going to the courtroom without authority, because frankly, no courts in Nigeria have decided on that case. So now, if all I would do was to go the old journey with the strength of litigator, then my mileage will be limited. But if I had to borrow from my strength as a researcher, then of course I will go a long distance. So that is the point. Now, being a legal researcher complements your success, your hard work, and give you success as a litigator. Because quite a number of things you need to know now that other litigators don't know, you readily find answers to.
Countries. Do you think social media is the right tool for expression given the casual nature of software application and the number of fake users online? And if yes, to what extent should social media expression be permissible, according to you?
Yeah, thank you so much, Ross. I must say that to me, social media is one of the best things that has happened to humans and democracy in the last 20 years. Now, if you look at it, about 20 years ago, now the media was actually only accessible to the elite, to the educated people. Now, but if we all look at it, now freedom of expression as given by articles of Indian Constitution, as sections of the Nigerian Constitution, and all over the world, now are not, is that expression, that right is not given to educated people alone. It's not given to people in power alone. It's given to every citizen, in fact, every resident in that country. So now, and of course, you will agree with me that almost all nations around the world have illiterate people with them. So are we saying we have a set of rights for the educated people, another set of rights for the uneducated people? That's not correct. So what social media has done is that even people can, in their local language, on a Facebook account, they can actually post something, express themselves about their government, about the government's activities, about any inequality in their society. Now, and that was not possible 20 years ago, because you had to be perhaps a professor of politics, a professor of politics, a professor of English before you could even access and have your article published by those newspaper companies. Now, but today, any person around the world that can own a smartphone can open a Twitter account, can tweet something. And when you look at it, freedom of expression is the right to express myself without interference. Without, and in fact, it's a right that is not given by the government. So it is the right that cannot be taken away by the government. Now, so when you look at it clearly, it is a right that that social media has given so much leverage and mileage to. But that said, does social media have its downsides? Definitely it does. Now, of course, today we live with us the concept of hate speech, fake information, misinformation, and disinformation. So the question should be that, so to what extent, now your question is, to what extent should it be permissible? Yes, I think our use of social media should be checked. But I will tell you sincerely that it should not be checked by legislation. Now, you do not, I repeat, you do not stop fake speech, hate speech by legislation. When you do that, then you actually open a floodgate of further fake speech. And I'm going to give you an example. Now, let's say today, there is a publication somewhere that the government of, let's say the government, the central government of India declares that cutting of grass at the state house is cost the government 1 trillion rupees. Now, and to many of us, that's a whopping sum, that's outrageous, that's not justifiable. Now, maybe somebody tweeted that, and the government is saying, wow, that is fake news, that's misinformation. So instead of the government coming up and debunk it as first speech and giving us the right information, the government goes after that fellow who tweeted that fake information, fake news, arrested him and jailed him. But you will agree with me that that has not solved the problem that was created by that speech. Is that correct? Now, so when you look at that, so the government will punish that citizen. Punishing that citizen will further increase the suspicion on the part of citizen that, well, our government has something to hide. That's why it goes after this fellow. But if you do not have anything to hide, now goes on the air, you go on the air and tell us that that information is fake. We did not approve 1 trillion rupees to cut grass. What we approved was 1 million rupees. Now, we have a reason to believe it. Then let the other fellow who gave fake information or fake news come up and debunk what the government has said. So I believe that the use of social media should be responsible, but not regulated by legislation. That will rather be counterproductive, because even in the process, you will end up creating what is called chilling effect in the system. Because chilling effect is that the moment I am arrested for writing something about the government, even when other citizens ask the genuine information about the government, they will be afraid of arrest. They'll be afraid of prosecution. They'll be afraid of torture. And by that, we live in a society where we cannot live as humans that are free to express themselves.
So rightly said. My next question to you is, in case you have had the chance to analyze the Indian legal framework on digital rights, where do you think India stands in the digital rights sphere worldwide, and where is the scope of improvement?
Wow, that's a very exciting question for me, because I tell you, let me first lay this foundation. Digital rights are evolving all over the world. Now, no country, including the United States, can claim that it has well-established legal framework and systems, jurisprudence for digital rights. Now, I will not tell you sincerely. Let me start from the legal framework. Now, India, to me, seems to be one of very encouraging jurisdictions around the world. Now, of course, India today has what is known as Information Technology Act. Of course, that law itself has its downside. I mean, Section 66A of that law was used to restrict online expression until 2015, when the Supreme Court of India declared that section unconstitutional and say was struck down. Now, but away from that, in 2019 March, the Ministry of Electronics and Information Technology introduced the most comprehensive, I repeat, the most comprehensive personal data protection bill to the Indian Parliament. Now, and that's very comprehensive because now it does not only share so many similarities with the legal framework that applies to protect personal data in Europe, which is GDPR, but then it also it localizes its provisions to the Indian society. Of course, I will say that same provision too has its downside, but then that is one bill that is very promising on its face. Let me give an example. The preamble to that 98 section bill says something. And what it says is this. It says the concept of data protection is an essential part of informational privacy, meaning data protection by that law is treated as an extension of privacy as a right, as a fundamental human right. And if you could recall, in a particular landmark judgment in 2017, the Supreme Court of India declared privacy to be a fundamental human right under Article 21 of the Constitution of India. Now, so what am I saying? The Personal Data Protection Bill is very promising. Of course, it has challenges. One of the challenges is that bill gives the government powers to exempt itself from complying with the prescriptions of the bill. Now, that bill seeks to regulate how personal data of persons and residents in India are processed to ensure their privacy and their data are safe. But even the government and its agencies, as data controllers, that should comply, that should be responsible to the same legislation. The legislation now gives the government power to exempt itself. And if you look at it, government is one of the largest data controllers all over the world. Because let's look at it, for example, the digital identity system in India, which is Aadhaar. Now, that itself is controlled by the government. Now, the Indian government therefore has access to data of over 1.3 billion people. That is large, that is huge. So now, if there is any unlawful processing of data of such persons, then I tell you that would be very dangerous to the system. So, but limit that, I have stated the fact that bill is promising on its face. Now, I expect the parliament, while still working on that bill, to look into some of the challenges, which is the one I pointed out that further, the bill gives the government, even as a controller, to exempt itself from complying with the provisions of the bill. But if we should go to the area of judicial intervention, I will tell you the Indian judiciary daily excites me. I must tell you that. Now, because I said it that if you look at the concept of online restriction, the judgment by the Supreme Court of India in 2015 in the popular case of Shreya Singh and Union of India, where the court declared Section 66A of ITA on constitutional and structural down, it was a fantastic one. It was a big breakthrough. Because up to that time, if you post anything on Facebook or tweet something and somebody somewhere finds it grossly offensive, then you may spend some years behind the bars. So you may have to, in some other cases, you may have to pay a huge sum as fine. Interestingly, most ex-colonies of Great Britain, including India, Kenya, and Nigeria, they copied that provision from a particular law in the United Kingdom, and they just pasted it in their bodies of law. So, but in 2015, Supreme Court of India took that bold step and declared that provision, unconstitutional and struck it down. Because it said that if you post anything and it's grossly offensive, then you are liable of an offense. Then what is the right to freedom of expression? If I cannot disagree with my government, what is the right to express myself when I cannot disagree with how my affairs as a citizen of my country are run? Then, of course, in 2016, Kenya High Court also took a bold step and declared their own equivalent provision unconstitutional. And that actually gave me the courage, in 2017, to go to the Federal Court in Lagos, Nigeria, to challenge that provision, which is the Section 24 of the Cybercrime Act. Now, what am I saying? Now, if the Supreme Court of India had not taken that bold step, then perhaps I wouldn't have any authority to rely on. Now, another thing is a very brilliant case of Justice K.S. Putaswamy and Union of India, where the Supreme Court of India also declared right to privacy as a fundamental human right under Article 21. So now I can tell you categorically that the judiciary in India is actually quite sharing the digital rights ecosystem around the world. But then it is not all Huru yet, because there's so much work to be done, because we live in a world that is changing at the speed of light.
Rightly said, sir. Sir, so currently the WhatsApp privacy update has spurred a huge debate worldwide and has created a potential threat on your privacy at the cost of instant messaging. What is your take on that issue?
Now, can I take that question again, please? Can you take it again?
Yes, sir. Yes, sir. Yes, sir. Sir, currently the WhatsApp privacy update has spurred a huge debate
Yes.
worldwide and has created a potential threat on our privacy at the cost of instant messaging. What is your take on that issue?
Well, the issue of the WhatsApp updating its privacy is being an issue of global concern. For me, I would first say it is an issue with two sides. The first side is irresponsibility. Do I call it irresponsibility, or yes? Let me call it an issue of irresponsibility on part of government, and two, taking advantage of that irresponsibility on part of the big techs, including WhatsApp, Facebook, and the rest. Now, if you look at it, you will realize, trust with me, that that particular updated policy does not apply to Europe. It doesn't apply in European Union. In fact, from that 4th of January that it was announced, it was stated clearly in that announcement that it will not apply to people in European Union. Now, one of the things why that happened was that in 2016, European Union came up with the world's most comprehensive legal framework on data protection, which is known as General Data Protection Regulation, GDPR. And GDPR provides that one, you cannot process the personal data of any person, any data subject, for any other purpose other than the purpose stated while collecting the data. What does that mean? Now, while I'm collecting your data now, Charles, for purpose of an interview, it becomes unlawful if after that time I begin to process your personal data for marketing purpose. Say, for example, after this interview, you start receiving advertisements from me, maybe advertisement of communication gadget. Now, GDPR says that's unlawful. Now, number two, you cannot process personal data of any data subject as a Europe. Now, those two are quite fundamental, and sincerely speaking, it has really protected the residents of Europe. Now, but when you look at the rest of the world, particularly the global south, Asia, Africa, you realize that most of them do not even have any data protection regulation. In Nigeria today, what we have is called NDPR, that's Nigeria Data Protection Regulation 2019. But I tell you, even government agencies, they are not even regarding the regulation. To them, oh, it's a mere regulation. It is not an act of the National Assembly. Now, look at it now. Even India, as promising as I've lauded, the personal data protection bill, it is still a bill. It's not a law yet. It doesn't have a binding force. Now, even though Section 5 of Personal Data Protection Bill in India provides that personal data of data principal, because in that bill, as opposed to the provision in GDPR, which uses data subject, in personal data protection bill, it uses data principal for the individual, which is the owner of data. So it provides that the processing of personal data of a data principal shall only be in accordance with the purpose, for the purpose it was collected. Just like I told you earlier, I couldn't have actually collected your personal data for the purpose of this interview, and afterwards you are receiving advertisement for communication gadget from me. That's unlawful. So now that actually comes to the issue of responsibility on behalf of government to stand to the need to the occasion to protect the personal data of their citizens and residents. So for me, now with the WhatsApp updated privacy policy, now subscribers of WhatsApp are now required to consent to WhatsApp sharing their personal data with Facebook, which is a sister company. But then, sure, this is the challenge. Now, if we never had any challenge, any issue with WhatsApp, with Facebook in the past, then we wouldn't have had a challenge. We wouldn't have had any feeling. But you and I were alive, on this planet when the issue of Cambridge Analytica came up. Now, when the issue of illegal mining of personal data came up, and all of these allegations were slammed against Facebook. As I speak to you today, Facebook just last year, towards the end of last year, was still slammed with a very huge fine in Europe, on the allegation of illegal mining of personal data. So the question is this: if I trust you with my personal data, but you have a colleague that has been alleged in the past of compromising people's data, and now you're saying, okay, Solomon, don't worry, trust me with your data. And I've trusted my data all along. But today, you just show up there, Solomon, you know what? You need to consent that I can share your data with B. But this is B that you and I, the whole world knows that is compromising people's data. Then, do I have a reason to distrust you? Do I have a reason to say, oh, I cannot go ahead? And that's the concern for so many people around the world. Now, let me say this, Shual. Now, Facebook and WhatsApp keep telling us they have been sponsoring adverts all across the world. That, okay, they are not going to access our communication. They will not do this, they will not do that. But our metadata are still accessible to them. They will still be able to share our metadata. In fact, it was stated clearly for the purpose of marketing. So if that is the case, then there's a huge concern. And as I can tell you today, even the 2016 updated policy, there's still a case on it pending at the Supreme Court in India today. A case was filed in India, and the case is at the Supreme Court, on the 2016 updated policy. So this didn't just start today. So now knowing that there's a background to it, it's all the reason why everyone should be legitimately concerned.
That's right, sir. So going on, so digital identity has been identified to be a fundamental aspect to the growth of an economy in today's world, which is so technologically driven. So could you tell me what are the intricacies of digital identity and how countries in the global south responding to this regard?
Thank you, the Bishop, for this question. I must say that digital identity is actually one of the, maybe I'll call it the eighth wonder of our world. Eighth wonder of our world because many years ago, I would have to leave the comfort of my home before I could do financial transaction. I would have to enter the bank. I could recall some years back, I read a quote attributed to Bill Gates when he said, banking is necessary, banks are not. Meaning, all of us have to do banking, but we don't need banks to do banking. Meaning, we don't have to enter the premises of a bank to actually carry out banking transaction. Now, but you see, all of that is actually a step, for a step ahead or a prelude, brother, to digital identity. Now, with digital identity, now all I need is a number, a digital number that give me access to services, both from private sector and public agencies. Now, with my digital identity, now I do not need to carry out any paper form of identity to be identified. Now, when I need to access any benefit from the government, I can easily do that by just calling out or punching into a particular device the number. Now, this is it. Digital identity in itself is a matter that has many sides. And one of the sides is actually the concern for protection of personal data. Now, let me give an example. Now, imagine I work in a health facility and you step into the health facility complaining of headache. Now, while you're there, then I need to access your health records as a doctor to know the right prescription to give to you. Now, while accessing your record, and I could access all your personal data, the last time you had headache, the last time you had body temperature, a very high body temperature, and all of that. And of course, maybe for some reason, my friend doesn't like your face, and my friend has been all out to actually to harm your reputation. Now, I can easily access your personal data and say, oh, the patient is someone who has headache every day of her life. Now, the point is this. Now, that is easily possible if there are no measures of protection to your personal data that is tied to your digital identity. Now, one of the challenges has been the issue of a comprehensive legal framework for it. Now, I tell you today, now that was one of the challenges that ADA had, in India, when people actually came up that the personal data of citizens were being sold for as little as 500 rupees, from, ADA. Now, so that's actually a challenge because for whatever it is, for whatever it stands for, I have only submitted my data to the government for purpose of digital identity. Now, and I realize that companies are making huge revenue, on my personal data without my consent, without me benefiting from it. Now, so that gives a whole lot of concern. And in nations around the world, one of the things that has to be done when digital identity will have to be successfully carried out will be what is called data protection impact assessment. So every nation that wants to put up a successful digital identity project has to conduct such an assessment to be sure that what are the risks associated with processing personal data of the data subject. For example, the personnel that will be charged with the responsibility of collecting data, do they have the understanding that they have to abide by the legal framework that governs protecting personal data? Do they know that they have a legal responsibility not to disclose personal data to any unauthorized person? These are some of the concerns that show up when we discuss the concept of digital identity. But I tell you today, just like I stated at the outset, digital identity is not only essential to growth of the economy, it is, to me, the eighth wonder of our world.
Rightly said, sir. So, sir, moving forward, if we are not wrong, you have personally worked on the case of Section 24 of Cybercrimes Act, which allegedly infringes online expression. Could you tell us more about your experience in spotting the problem and what hope lies ahead?
Okay, thank you, Shaz. For me, if you look at it, the good thing about digital rights is that the expression of digital rights are linked, with each other and from one nation to the other nation. If you look at some of my responses, now I've been able to link India with Nigeria, with Kenya, with the UK, and all of that. Now, in 2017, when I first challenged that provision, you see, let me tell you how interesting that provision is. Now, if I present to you Section 24 of the Cybercrime Act, and you read it, and I take it away from you, I give you Section 66A of Information Technology Act, India. You will tell me, I've read this before. I said, no, you didn't read it. What you read is Nigeria's Section 24 of the Cybercrime Act. Okay, if I take that away from you, and I give you Section 29 of Kenya Information and Communication Technology Act, you will tell me, but this is the same. I will say, no, 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 no. It's not what I gave you. This is from Kenya. The other one was from Nigeria. The other one is from India. Now, what all of those nations who are actually ex-colonies of Great Britain did was that they went to Post Office Act of 1935, a United Kingdom, and copied a provision there. Now, if you look at it, most ex-colonies of the United Kingdom had their early laws, as what you can call colonial bequest from the Great Britain. Now, most of them started governing their countries with laws from Great Britain. But of course, over time, some of those laws, got repealed. Some were amended, while of course they now add, laws that directly speak to the peculiarity of the people. So, Section 24 of the Cybercrime Act in Nigeria clearly provides that if you, through computer systems or network, send a message or matter that is grossly offensive, then you have committed an offense. And of course, having committed an offense under the Act, you can find yourself behind the bar. I mean, you can spend the next 3 years of your life, in the prison, or you have to pay a fine of 7 million naira, which is like 20,000 US dollars. Now, the question is this, Charles: who determines what is grossly offensive? That is one question that even the law itself does not answer. Now, at what extent will my tweet that Schwarz is not a nice person, at what extent will it be offensive? Now, if I say Schwarz is not a nice person, or Devisha is not a nice person, Schwarz may not take an offense, Devisha may take an offense. So that law does not even prescribe at what extent would the matter or message or video have actually been grossly offensive. Going further, subsection 24(1)(b) now provides that if I send a matter or message that is grossly, that creates criminal intimidation, now needless anxiety, let me create a picture around that. If you post a picture now, or you send a WhatsApp message that there is uprising in New Delhi, or there's an accident, in New Delhi. Now, and the Devisha was actually coming from a particular place that she had to enter New Delhi. But because of that, she saw it as caution. She didn't go into New Delhi. Now, at the end of the day, the following day, she found out that that story is not true. Or it does not happen. What happened, the accident didn't happen in New Delhi. Now, by that law, she can press a criminal charge against you. Now, when you are actually all out to save her life. Now, you now have a law that is not only creating difficulty in the system, but this is a law that's not reasonably justifiable in a democratic society. Now, so that was the position in Shreya Singh and Union of India, where Supreme Court of India looked at it and declared that no, this law is not reasonably justifiable in a democratic society. And of course, the good thing is that as of today, India is the world's largest democracy. So, and the Supreme Court of India, did something fantastic when it, declared it unconstitutional and struck it down. Though I must add also that I am aware that even after that judgment by the apex court in India, some other prosecutions have been premised on the same law. Now, that problem is not peculiar to India. It's actually is kind of a problem you find in most countries in the global south. Now, but so now when I came across that judgment, by reason of my research, now I took the judgment, I took the one in Kenya, then I filed the action at the Federal High Court in Lagos, Nigeria. Even though, as of today, the appeal is still pending at the Supreme Court in Nigeria. Now, last year, July, the ECOWAS Court, which is a regional court for all countries in the ECOWAS region in Africa, now had actually directed the federal government of Nigeria to amend or repeal that law. Because how dare do you imprison someone for insult? And now let me tell you the exact thing about it. In 2017, when I went to court, many citizens could not see a reason behind doing that. First of all, this fellow was not arrested. Second of all, I mean, he is not being prosecuted for anything. But the good thing is that in Nigeria, our section 46 of our constitution provides that any citizen can approach the court for a redress if he sees that his right, any of his right, fundamental human rights, has been contravened, is being contravened, or is likely to be contravened. Now, so I approach the court based on the third lane of likelihood. Because trust, if I have a law that says if I use computer system or network to say anything and that thing is grossly offensive, I may spend the next 3 years of my life, in prison. Now, such a law has a strong likelihood to put me in jail. Now, because it means that I cannot question the affairs of governance of my whole nation. Do you understand? So that is actually what gave me that impetus to go to court and challenge it. But then, and I tell you, even after that, even after the judgment of ECOWAS court, now the Nigerian police and Nigerian authority are still prosecuting people based on that provision. But then, what do we do? Do we just fold our hands? No. So the only thing we can do as researchers is now keep telling the authority, keep putting out the information that, come, this law is not peculiar to our nation. In India, they had it. They have declared it unconstitutional. In Kenya, they had it. They declared it unconstitutional. In Nigeria, we keep saying it that, okay, should we keep it? Should we not keep it? Now, beyond that, as litigators, we should keep going to court. We should keep challenging any repressive legislation. Now, one of the things we do in my organization called Digital Lawyers Initiative is that every day when we come across any provision of any law or regulation that we believe that it restricts digital rights, now we go to court and challenge it under what's called strategic litigation. Because that it does not happen to me does not mean it cannot happen to me. Now, to close on that, we find solace in the precious words of the German priest, Martin Niemöller, when he said, they came for the trade unionists. I did not speak up because I was not a trade unionist. They came for socialists. I did not speak up because I was a socialist. They came for the Jews. I didn't speak up because I wasn't a Jew. And then they came for me, but there was no one left to speak for me. That's the point. So we believe that we don't have to wait until we are being prosecuted on a justifiable law before we can approach the court to declare that law as unconstitutional and not justifiable.
Yes, sir. What a wonderful explanation to that. Lastly, sir, to conclude our interview, I would ask, what advice would you like to give to the new generation of researchers and litigators and law students aspiring to get into litigation and research?
Thank you so much, Vidisha. I must say at this stage that there are two things I will say. The first one, be ready. The second one, be creative. In be ready, I think none of us needs a very long sermon on the fact that we now live in a world that changes at the speed of light. Now, our realities as of yesterday are no longer our realities today. Our laws of yesterday could not even deal with our realities as of today. So we now live in a world that keeps changing every second. And if that is the reality, whether as an aspiring lawyer, a law student, a litigator, a researcher, the only way to be relevant and keep being relevant is actually to be ready to take on a world that changes at the speed of light. Now, you will need to be ready for the realities of a current world. Two, we need to be creative. Now, there's always in being creative, to me, being creative also encompasses being proactive. Now, so in this situation, we don't just have to sit down and wait until something happens before we can address it. Sometimes we may have to sit down and contemplate what could happen. Sometimes, and this actually informs how laws are made. And I tell you, sincerely speaking, now, for example, Nigeria on paper has one of the most comprehensive and protective, provisions of fundamental human rights anywhere in the world. Because it allows you to challenge anything when there's a likelihood of infringement of that right. But the question is that, like I told you, that that you can challenge does not necessarily mean that you may get the nod of the court. That's one thing. Now, but more importantly, I think the fact that some people sat down and said, look, now we don't really have to have all our fundamental human rights contravened before we can access the court. They're going to do that. Just like I will tell people. Now, if people will say experience is the best teacher, but if we are going to have experience of accidents before we are well taught about driving, then we may not live to apply that learning from the accident, because some accident may end up being fatal. So my point, so that was actually what led the drafters of that constitution to say, wait, let people be able to approach the court when there is an impending infringement of their fundamental human rights. So that is being proactive. That is being creative. So I challenge every lawyer out there, every litigator out there, every researcher out there, and every law student out there, that please be creative. Now, do beyond the ordinary. Don't wait until things happen to you. Make things happen. Chart a course, chart a path. And of course, many people think, particularly law students and lawyers, we always think the concept of creativity is actually exclusive, right of scientific inventors, of technological inventors. No. As a matter of fact, now lawyers are more saddled with a huge responsibility of creativity today, because we need laws to move at the pace of technological inventions. If laws do not move at the same pace with invention, then we are going to someday have invention that will consume us. So that is why I say again, be ready and be creative. Thank you.
Thank you, sir, for that wonderful session. It was a delight to hear your perspectives and the immense amount of knowledge you have on this field. I'm sure we all, as well as the viewers, will be very enlightened after this session. First of all, thank you so much for spending a Sunday afternoon with us and answering all our questions very enthusiastically. It was a pleasure. And we from Tathya extend a big thank you to you for telling us what you know about this field. Thank you so much. Thank you so much.
It is my pleasure. Thank you.
Yes, sir.
And Charles, thank you so much. Thank you for the invitation. I look forward to some other time, and I look forward to future engagement with you.
Yes, sir. Thank you so much, sir. So I will.
So bye for now.
Yes, sir. I will stop the recording now.